You're listening to Best Practices with Kenny Berger. On this podcast, we talk with the country's top trial lawyers about their approaches to every aspect of practice, from case selection to closing argument. And our guest today is my good friend, live from New York, Stephen Williamson. Stephen, welcome back to the podcast.
Thank you, Kenny. Good to see you. Good to be back.
You too, man. And you and I got to spend some time in person together at the TLU seminar out in Vegas back in October. And at that time, you had a trial coming up that we're getting ready to talk a little bit about. But before we talk about your fall 2024 verdict, I want to talk about a case that's also recent, in which you got a $117 million verdict.
Yes, sir.
All right. So $117 million cases, not something you see quite every day. So give us a little bit of the background.
So obviously, with the result that we had, by the end of it, the stars came together, the stars were aligned. But it was a case, during the litigation and a trial that had a lot of challenges to it. I represented a guy who was actually a physician, and he was a young physician at the beginning of his career when he got hurt, when this incident happened. He was not long into his first job as a fully trained physician after his residency and his fellowship, when he was in a parking garage just near the hospital where he was working. The hospital that was his employer had contracted with a nearby garage, to have a place where the doctors could park. And, it was part of the package that the doctors got. And there were valets. And it was a normal morning when he was going to work. He pulls into the garage, leaves his car where he normally would leave it to have the valet get in and park it. And that's what happened. He got his bag, he got out, he started to walk away. The valet gets in the car and backs it up. And my client was actually hit by his own car, believe it or not. He had a sedan, and he's a relatively tall guy, about 6 feet. And he was walking away. So given his height and sort of the height of the back of the trunk, the back of the vehicle hit him in his back, in his lumbar spine. And, there was no question, and this was a big defense in the case, that, it happened in a garage. The vehicle was backing up. It was going at a low speed. It hit him, but it wasn't a big impact at a high rate of speed. He bounced forward. He kind of went flying, but he didn't even fall to the ground. He kind of caught himself on one leg and a knee and an arm and got up. And no medical personnel were called to the scene. The valet obviously got out, and it was reported. It wasn't not reported. It was later an accident report. But my client, he walked away. He walked out of the garage. He walked the block and a half to the hospital. He told his, I think it was like his department manager, what had happened. And he ended up getting seen by one of his colleagues a little bit later that morning, and then went home later in the day. So it's a pedestrian case. It was something that happened at a low speed. There wasn't immediate medical attention at the scene, but, it was memorialized and he was checked out. And then, the other sort of, beginning element of describing the case was that, he had low back pain in the days and weeks that followed this, and, had an MRI. So he's a physician. So he obviously, knew how to get medical care. And I think he started physical therapy right at the outset. But when he had his first lumbar MRI, which was, I think, about 3 or 4 weeks after the incident, it didn't really show any evidence of trauma. There was not even any herniated discs. But what there was at the L5-S1 level was a finding of bilateral pars defects. And they were described, as they often are, as congenital. And I don't know if you know what the pars are, but they're small bones in the spine, very small bones. And about 5% of the population has these pars defects, these little fissures or cracks or fractures in the pars. Some people are born with them. and some people develop them in adolescence. But most of the folks who have pars defects, they're asymptomatic. They don't even know that they have them, and they may develop, some symptoms later in life. And in addition to showing these pars defects, uh, he 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 had, it was shown on the MRI, um, a spondylolisthesis, which is a slippage of one vertebrae over the other. I paused because I was trying to remember the grade, but it was the most mild grade of spondylolisthesis. So there were two findings at the L5S1 level: the spondylolisthesis and the bilateral pars defects, which were described as congenital. But these were both things that aren't typically associated with trauma, certainly not in, our world of litigation and motor vehicle cases. And the pars defects especially. And later in the case, we even acknowledged that they predated the accident. They weren't caused traumatically by the incident. But that was sort of the genesis of a big dispute and a big defense in the case, that whatever was going on with this guy, it predated the accident. And, events and the medical treatment and his symptoms cascaded from there. But, the short of it is that he went back to work, and he was on and off trying to work for a while. I think the incident happened in January of 2016. He worked up until August, on and off. And then ultimately in August, couldn't hack it. And we could talk about like what happened on the job for him. Physicians, like lawyers in a lot of ways, are measured by their productivity. How many patients they see, how many procedures they do. That's how revenue is
Was
generated. Yep.
was he an internist?
He was a non-operative orthopedist in the orthopedic department of a New York hospital. He had originally done his residency in family medicine, but then wanted to get into sports medicine and got a fellowship in sports medicine. And then his first job after his fellowship as a fully trained doctor, which is when this happened, was as a sort of a non-operative kind of pain management orthopedic in this orthopedic department. But he wasn't making the grade. He wasn't making the cut in terms of hours, productivity, procedures, patients, and ultimately had a big crossroads with the department, and was fired from the job in August. And things cascaded from there, but there ended up being a.
What were the reasons per your client that he wasn't able to make the grade, to see the patients, to perform the work that the job required?
So what happened over those first 6 or 9 months after the incident is that he was progressively and highly symptomatic. He had an unstable lumbar spine. What this accident did was it took the asymptomatic pars on both sides and made them symptomatic. And what it probably did is it either caused the spondylolisthesis to occur, or it worsened what was a pre-existing spondylolisthesis, and it made that lower part of his lumbar spine unstable and very painful. And so he had great difficulty doing anything physical, including getting to work and working. It was a great struggle for him. And he was working, and then he would take some weeks off, and he was trying one treatment after another. And he was trying, all the cutting edge treatments to see if he could get better. He was, you know, on the computer every day looking at, options, because he's a physician. So he was really trying to be proactive to get better, but he wasn't. And what happened in that first year is he saw, I think, three or four prominent spine surgeons in New York. Again, he's a physician, so he knew how to look for, the best doctors. And they all recommended that he do an L5S1 fusion. That was like the consensus of recommendation. But again, because he was a physician and he read the studies on the long-term effects of fusions and how, you could be facing adjacent segment disease down the road. And he was only 37 at the time. He was reticent about doing the fusion. And he found a physician, a surgeon, who offered him an alternative, which was to do a pars repair, which was a smaller, more targeted procedure to go in and try with some small hardware to fuse the pars. And so he opted for that instead. And unfortunately, when that surgery was done, there was a complication. The surgeon didn't make any mistakes, but it's a difficult procedure to accomplish successfully because what the surgeon did and what he needed to do was he used a product called BMP, which is bone morphogenetic protein, which it's basically an artificial product to help stimulate bone growth. And the idea is to, with any kind of fusion, it's used a lot to help the bones fuse around the hardware. And so this first surgeon put just a little bit of BMP in there because it was a small space, the nerves were right there, and the bone is small, to try and get the necessary bone growth around the pars with the screw that he put in. But even with the small amount of BMP he put in, there was an overgrowth of bone because the BMP worked too well, even the small amount he used. And when the BMP overgrew, it started to compress the nearby nerve. And so then he started to have additional problems with the compression of the nerve from the BMP overgrowth. And then he had to have a laminectomy to try and make space for the nerve. And there was a 5 or 6 year saga of unfolding treatment and disability before we got to trial. So there's more there, but that's kind of the beginning.
Stephen, just to be clear, your doctor, no history of lower back issues before the car backs into him.
So this was an interesting issue because we had a low speed incident with no big obvious trauma. We had a congenital condition, certainly pre-existing. So we were acknowledging very much that this was an aggravation of a natural condition that he had, and we prosecuted the case at trial very much that he was an eggshell plaintiff, and that he was the classic asymptomatic guy with a quiescent condition underneath the surface that he wasn't even aware of, that was not causing him any limitation or problems, but that made him more vulnerable should he be subjected to the kind of trauma that occurred when this vehicle at a low speed backed it up and actually hit him in the back, right where that level is. And I made a big effort at trial to not only, to prove to the jury that he was not only asymptomatic, but he was strong and healthy and functioning and without limitation. Because I'm a big believer that in any kind of medically, where there's a contest, a dispute about medical causation, you have to go back before the date of the trauma to, as best as you can, prove with employment records or primary care doctor records or other kinds of records and photographs that your client had no limitations, had no pain, and had no similar symptoms before. It's not enough for there to be an absence of records. It's not enough for the plaintiff to say it or for me, the lawyer, to say it, because number one, as you know, a defense lawyer can easily step into that void and say, well, we don't really know, and we're taking the plaintiff's word for it. Or, it's the plaintiff who controls access to his medical history and, his medical records in the past. So if he says he doesn't have, or it didn't happen, we have to take his word for it. You never want to be in that dynamic. And I think that we as plaintiffs are held to such a higher standard on these kinds of issues. Again, particularly in cases where there's a real dispute about medical causation and there's a question about pre-existing and the like, and whether the trauma was sufficient to cause what you're claiming. So in this case, and I do this in almost all my cases to whatever degree I can, we got a ton of records from before. We got his fellowship records. We got his residency records. I had him give me a ton of photographs of him in the years before the incident, and we had those up on the screen in the courtroom during the direct testimony. So there was repetitive, strong proof positive that he was very much okay, more than okay. There were photos of him in the year and the years before the incident where he was on the beach without a shirt and he was muscular. This was an athletic guy beforehand, and he came from nothing. He worked his way through medical school. He was moonlighting when he was doing his residency and his fellowship, and that ties into some other things we should talk about in the case. But we proved, I think, to anybody's satisfaction, independent of what we were saying, that he had no problems before, and that whatever was going on was asymptomatic and beneath the surface.
Well done. And by the time y'all get to trial, this is 5 or 6 years into this medical
Saga.
saga, kind of this pre-trial purgatory for the poor guy. You'll get to trial. Walk us through what jury selection in this case looks like. Or if you want to start even before that, if there were major pretrial motions and rulings even prior to, be it jury selection or opening statement.
Well, certainly in jury selection, I was concerned a bit about money, because we had a very big lost wage claim, given that he was a physician and that he was cut down in the beginning of his career. So I knew that at the end of the case, I was going to be asking for a large sum of money on the lost wages, along with, the other categories. And so I voir dired a lot on whether the jury would be comfortable if the evidence was there, um, you know, providing in their verdict, sums of money that were in the tens of millions and more, and making sure that that was something that they would be willing to do, if the evidence was there. And, another related concern was I was trying it in a venue in the Bronx in New York City, which is traditionally known to be a great plaintiff's venue, but it's a borough of New York City that in a lot of ways is middle class and working class. It's very ethnically diverse. There's a lot of Hispanics, Latinos, and African Americans. My guy was from the Middle East by origin. He was an immigrant. He was not born in this country. He was born in a Middle Eastern country that he came from. He was a Muslim, and he was a physician, even though he came from nothing, and he worked, built himself up by his own bootstraps. He had become a physician by the time this happened. And so I was also concerned about how the pool of jurors in the Bronx would respond to him. And so that was another concern. Another thing that I was kind of laying the groundwork for in jury selection was that I knew that they were going to call my guy an exaggerator and a malingerer, because two of the defense doctors had been very aggressive in their reports and had been very pointed in the language that they used. And one of them came right out and called him a malingerer. But they didn't like this guy. They thought he was faking. And I had the sense from my interactions with the defense before trial that that was the sense from the lawyer and from the defense, so to speak, who was defending the case. And my plan from the beginning was to draw them out and call them out on that, and use Rick Friedman's polarizing the case strategy, which I ultimately did, I think, with a lot of success, and it was a big part of what led to the dynamic that resulted in this outsized verdict. But I sort of laid some of the groundwork for that. But my philosophy overall in jury selection, and it was reflected in this case, is really establishing credibility at the outset, and really dealing with whatever weak points you have in your case as fully and as frontally as possible, and really taking advantage of the fact that you get to go first, and owning that stuff in a wholehearted way, and making sure that whatever bad facts there are, whatever defenses the defense attorney is going to be articulating, that they don't hear any of that stuff for the first time from him or from her, that all of it gets spoken about by me first, with what is appropriate context and appropriate description, so it doesn't get mischaracterized. And we did a lot of that here. So that's
And
some of what happened in jury selection.
Stephen, let me ask you, looking ahead with with the diminished earning capacity or lost wage, that portion of the economic claim, uh,
Yeah.
of that size. Were there arguments from the defense, or were there valid points to be made regarding mitigation and perhaps other career paths for this doctor that, you know, wouldn't eat at the non-economics, but may bring that economic number down?
So had they chosen a different path, I think this case would have ended differently. I think what you just sort of hinted upon would have been a better and more successful strategy for the defense. But that is not the road they chose. They went for the win. They did not like this guy. And when I say they, it's everything from the principals defending the case to the doctors who were retained by them. The defense was that this was a minor incident, that was not the kind of thing that could cause injury. Whatever this guy is claiming is pre-existing. He had it before, and he is exaggerating. He is a doctor. He knows how to do it. He knows how to game the system. And the symptoms he says he has, the severity of them, his claimed disability from being able to work is not legit. It's not truthful. It's not real. And a lot of the treatment that he underwent, including the surgeries, was not medically necessary. They went after it in the most aggressive, sharp elbowed way. And there were a number of different reasons, I think, that led them to this path. But one of the things I think was that the wage claim, by the time I was done with it, and when I say done with it, I mean did it justice, was really substantial. And I think they had this idea that they had to eliminate the wage claim. And the only way to eliminate the wage claim, as opposed to mitigating it like you suggested, is to destroy the foundation, which is that there's a causally related disabling injury. And the only way to do that was to go after him as a faker and a fraud. And there were a lot of reasons why that was not the right move. It wasn't the right strategy for the defense in this case. And it ultimately backfired. I saw that it wasn't going to work and that it was at odds with a lot of the elements of the case, not just the medical evidence, which is always a mix of good and bad, but more his life story and how that life story tied into the timing of this incident and how, on a logical level, if the jury was going to believe the defense arguments that I just articulated, they would also, by association, by definition, have to believe that this guy was willing to throw away everything when he had just reached the mountaintop that he had been climbing to from nothing for decades. This is a guy who came to this country not speaking any English as an immigrant with nothing. His family came here with no money. They moved to a really poor neighborhood in Brooklyn. He didn't speak any English and was thrown into 11th grade in a New York City high school. And in the space of less than 2 years, not only learned English, but learned English and got good enough grades to graduate from high school on time, with marks that were high enough to get him into Brooklyn College. And then he worked while he was in school to put himself through Brooklyn College and taken loans, and then went from there to medical school. And, at one point really had a rift with his family because they wanted him to get married at a very young age because they came from this traditional Muslim culture. And he knew that if he got married before he finished his education, it would make his dreams of becoming a doctor, largely unattainable. So he was willing to kind of accept this rift with his family over going in a different direction. Gets through medical school, on his own nickel, and then the residency and the fellowship. And just months before this incident happened, he meets this girl who ultimately becomes his wife. So he is, finally done with all his training and schooling, in his first job as a fully trained doctor, for the first time making some real money. He's just gotten the girl who he's, ultimately going to marry. And, the marriage was going to kind of happen quickly because they come from a very traditional culture where, there's not a lot of, there's not a lot of dating that goes on before marriage. And so, the notion that at that point, after all of that, this guy was going to, you know, throw it all away, to sit home for 6 years and fake an injury and fake a disability and undergo treatments and surgeries that may not have been necessary. For what? For the hope, for the chance that one day in a courtroom 6 years later, a jury might give him, a sum of money that might rival what he could have made on his own. I just had this sense that all of that was going to, very much overwhelm and be completely at odds with what they were trying to peddle to the jury about, how this guy was a faker and a malingerer. And that was, how I sort of used the Friedman polarizing the case strategy, because it was right there in the defense doctor's reports. A lot of times we have cases, as you know, where they say it, but they say it indirectly. They say it, but they sort of dance around it. But then there are some cases, for whatever reason, they go further. And maybe it was because this guy was a physician, and they, sometimes if someone is like of your ilk or one of your colleagues, you're willing to be, for whatever reason, it could rub a guy the wrong way, or they're willing to be harder or tougher. Or maybe it was, coming from the principals in the defense from the beginning. I don't know. But they said these things about him being a malingerer, about symptom magnification, that he wasn't disabled, that the surgery wasn't indicated. And, so I knew that had to be part of the case. Whether they were going to embrace it to that degree at trial or not, I wasn't sure, but I knew that I could pull it out of them and I was going to get it because it was in the reports. And, at times the defense attorney sort of pulled back and was conscious of the fact that, having that be in stark relief wouldn't be good for him. But by summation, he, for whatever reason, he couldn't help himself, and he really went after the plaintiff and sort of echoed, what the doctors were saying, and went further. And I think that was a real gift for me going into my summation. So, the short answer to your question, they didn't do that. They didn't try and mitigate it. They tried to eliminate it with, this tar and feathering of him that ultimately wasn't successful. And, the other part of it is that I worked very, very hard to make the wage claim by the time of trial not only very strong, but very sophisticated. And I'll, if I do say so myself, in the sense that,
Tell us about it.
what's that? Yeah, in the sense
Tell us
that
about it.
I had the case for a long time. I was involved in this case from the beginning. And when I developed the wage claim to begin with, I retained an economist. And it was an economist who I have worked with before and have continued to work with. And she went to Department of Labor data. There's Department of Labor data for physicians and surgeons. And it's good national, federal, legit data on physician earnings and compensation. It's good, but it's not by any means the best. It's very general. It doesn't break down by geography. It doesn't break down by specialty. It doesn't break down by productivity. And productivity is a huge thing in the legal profession. How much lawyers make is often based on how hard they work. Also very true, as I said at the outset, with physicians in terms of how many patients, how many procedures, how many surgeries they're performing. Not all surgeons are created, not all doctors are created equal in terms of productivity. And so initially, I did disclosures on the wage claim with my economist and with this data that she had obtained from the Department of Labor. And the wage claim in its initial manifestation was large. It was over $10 million. But I had this sense that it wasn't complete and it wasn't accurate and it wasn't a full accounting of what his real losses were over what would have been a full career. And so I had, two concerns and challenges. One was that I was dealing with a guy who was at the very outset of his professional career. Although he had finished medical school and finished his residency and fellowship, he was only 5 months into his first job. So whether it's a doctor or a lawyer or an accountant or any professional in that situation, you don't have 3 or 4 or 5 years of tax returns to look at to have an earnings history and maybe to have the trajectory of an earnings history because you have a professional at the beginning. It's almost like having a client who becomes disabled in law school or medical school. There's a future there, there's potential, and there's real proof of the path up until that point and the potential, but there isn't an earnings history. So I had to deal with those questions about what his career likely would have been like, uh, given how hard he would have worked, what positions he would have been in, and the like. But I also felt that the data that I had just wasn't specific enough and wasn't accurate enough. And so I started to realize that I needed an expert in the specialty of physician compensation. And I went on this journey of looking for a physician compensation expert, which is something that I didn't even really know existed, but I had this sense that there had to be some kind of person out there who was an expert on physician compensation. And I didn't know where to look for this person, and I didn't know how to find this person. And I was really struggling for a while, but I knew I knew the claim was incomplete, and I knew it was very, very important, very substantial. So I was talking to folks and trying to figure it out. And someone suggested to me that if I could find a lawyer who had a specialty practice representing doctors, a lawyer who represented physicians, that lawyer might be able to point me in the right direction, might be able to find me the guy that I was looking for. So then I started looking for lawyers who represent doctors. And that was an easier thing to do. I found several lawyers who represent physicians who have these practices where that's what they do. And the first guy I was introduced to, or guys I was introduced to, were these accountants who have a accounting practice where they specialize in representing physicians and medical practices. And I started working with them. I told them who I was, about my guy in the case, and they were willing to potentially work with me. And I actually sent them a retainer check, and I started to work with them, and I started to send them documents. And I think had I continued with them, they would have been okay. They may not have been great, but I think with work, probably would have gotten me to a finish line. I don't know if it was the finish line that I ultimately got to. But as I was starting to work with them, one of these other lawyers who I had reached out to months before got back to me with a name. And that name was Michael McLafferty. This guy introduced me to a gentleman by the name of Michael McLafferty, who became my expert. And Michael is a guy who's spent his whole career in the healthcare field. He's worked at various healthcare companies. He's been the CEO of a couple of healthcare companies. And what he does now, and what he's done, I think, for the last dozen years or so, is that he has a private consultancy. And what he does is he negotiates deals, or he helps negotiate deals when medical practices are sold, when they're bought and sold. And I don't know how it is in your state, but in New York, there are several large health systems that own, most of the medical establishment in New York now. Like there's New York Presbyterian, there's the Mount Sinai system. The biggest one is the Northwell system, which used to be North Shore. And what happens, for example, in Long Island, is Northwell buys up a lot of the physician practices, and the practice becomes wholly owned by the system. And so if you have a situation where, let's say, you have an orthopedic group, you have 8 orthopedic surgeons in a private practice, and their practice is going to be sold to a system, the practice has to be valued. And the way the practice is valued is based on the productivity of the 8 orthopedic surgeons. It's all about their productivity, and how many patients they're seeing and how many surgeries they're doing. So McLafferty is the guy who comes in either representing the system or representing the medical practice and obtains the data that nobody can question, that really puts a value on the practice. And what I learned is that there are a couple of different entities in the United States that have this data on physician compensation. And one of them is known as MGMA, and that's the one that we ultimately worked with. And so the short of it is, not long after I started speaking to McLafferty, I realized I had found the right guy. And he started to educate me on all of this stuff and the MGMA data. And what basically happens is most hospitals and hospital systems and medical providers and physician practices, they feed data to MGMA. They're members of MGMA and they feed data, and then they can get the data back. It's like sort of a reciprocal relationship. And if you are a member of MGMA, you can access their system. And not only do they have a system with all this data, they have all of this software where you can run searches in the data based on different profiles. And so now we had access to data that was really the gold standard in the area of physician compensation, that could be searched by geographic region, that could be searched by specialty, and then could be divided up in percentage terms by productivity. Physicians in the 0 to 25% productivity level, 25 to 50, 50 to 75, and the like. And we eventually ran a search in my guy's geographic area that was a hybrid search of family medicine and sports medicine, which was his residency and his fellowship. And Mike told me, I'm not sure that there's going to be a hit. There may be, there may not, depends on the data. But there was. We got a hit in his region on these two specialties combined. And so we now had, irrefutable, unassailable data. And I had this guy who was a real expert in this area, who had a tremendous credential and knowledge. And what I did was I paired my economist with him. My vision from the beginning was to have the economist and the physician compensation expert work collaboratively as a team. And that's what they did. And by the time we were done with it, we had a wage claim that did full justice to what he would have earned over decades of a career. The wage claim went from 10 to 12 million to 25 to 30 million. And it was more accurate than the lower number done the first time. And it was based on data that nobody could mess with. And what it also did, it was we were able to present the jury with a number of different scenarios based on what they thought his productivity would be in future years and future decades. So I was in a position to say to the jury at the end, you heard from this guy. You saw all the evidence. You decide what kind of doctor he would have been had he had the chance. Would he have been, an average doctor? Would he have been above average? Or would he have been a star? And here are the different categories based on the percentage of productivity. Here's the number on the average. Here's the number that's better than average. And if you really think he would have excelled and hit the ball out of the park, here's the higher number. And so I think that's always a great thing, to empower the jury to make those decisions and to trust them that they can decide that, you gave them the testimony, you showed them the measure of the man, and let them decide. The ultimate conclusion is for them. I think they like it, and it's better and it's real.
Steve, I don't know if you'll have line item verdict forms or if you were able to deduce the amount of money the jurors came back with when it came to that lost wage claim.
Well, what happened was on the future pain and suffering and the future lost wages, they went much higher than anything I asked for or anything that was articulated by my experts. That's how you get to 117 million, because as much as the wage claim, had they put a number on it that was the high end of that productivity scale, the wage claim would have been, I think, in total around $30 million. They went higher than that on the futures, on the future pain and suffering, the future lost wages. So it was more than we asked for, and it was more than the evidence. So it's an itemized verdict to some degree, but the numbers were outsized, and I think part of the reason for that is what we talked about earlier, which is that the jury, I think, concluded at the end of the case that this incident very much ruined this guy's life and put him through a terrible 6 years of suffering. And then they dragged him through an awful experience with the litigation and then the trial, where in a public setting, they called him a fraud. And the jury didn't like that.
Steve, so how did the defense deal with the facts you laid out earlier on, in essence, this guy's climb, the incredible amount of hard work that he put in to get to where he was, and then that's the point at which it was taken from him. And yet there are arguments that's the point at which he said, all right, now the fraud begins. I mean, how did the defense, in essence, explain the years of hard work and effort and sacrifice that went into getting your guy where he was when they claimed that he suddenly woke up with the scheme and decided to malinger?
They didn't really have a counter to that. And that's, was part of the fallacy of what they were doing. They had this other narrative about him, which, just didn't have enough support, and it was more based on, you know, it's all pre-existing. A lot of it is uncontested that it's pre-existing. This was a minor thing that happened at a couple of miles an hour. And there were some inconsistencies, they said, in the medical records, and they just didn't believe that he couldn't go back to work. And then, all of the sort of very partisan, one-sided analysis and findings by their doctors. But they didn't have a counter to that other than this concept that he was a fraud and a fake. And I think what happened, you never know what the mindset is and the processes are on the other side. But I'm sure you experienced this. Sometimes when a case gets written up and evaluated by the defense early on in a certain way, it gets very hard for them to dislodge from that initial analysis. And the full scope of the damages in this case was not apparent at the beginning. I mean, the first MRI showed, not a lot of anything that wasn't pre-existing and congenital. He was back to work for a while. He didn't have surgery right away. The first surgery was a small procedure. I had every expectation in the beginning that he was going to go back to work, because when I first met him in that first year, if anything came across with this guy was his desire to get back to work. He did not want to have a case. He wanted to move on with his life. He's a physician. I mean, this was not in any way part of his calculus. But for a number of reasons, I think they developed this very, very negative idea about the case and his truthfulness. So one of the things that happened that I think they misconstrued was in the initial months after the accident, when he went for pain management and physical therapy, he went to doctors and medical practices that he knew. They were either people he worked with before or kind of friends of friends. And if you think about it, if you're a young doctor and you get hurt and you're in a metropolitan area where you've grown up and where you've gone to school, of course you're going to seek out people that you know and that you trust and that you're going to get some, a little extra love from, and who are going to care for you and have the credentials. But they didn't see it that way. They saw it like it was this conspiracy that, some of these people were out to help him or in cahoots with him, and that he felt that these were, medical offices where he could orchestrate things. They had this whole negative spin that, just didn't have enough juice to it, that it was gonna sell in the courtroom.
Yeah.
Not to say that we didn't, that we didn't have issues. There were a lot of medical causation issues in the case, and there were some real hurdles. But at the end of the day, when you have a strong narrative and they don't have the counter, it carries the day.
Stephen, what else stands out from either be it the jury selection portion of the trial or the trial itself that you think would be important for folks to hear?
One thing I will say is that the biggest reason we won the case and we got the verdict we got is because the jury really liked and believed my client and his wife. And as much as this ended up being an $117 million verdict, and he was a physician and he was disabled and he had this huge lost wage claim because he was at the beginning of his career, this was still like a soft tissue case. This was still a low speed incident that happened in a garage reversing where medical causation was very much in dispute. And it's my belief that anytime you have a case like that, you have to spend an enormous amount of time working with your client, getting them ready so that they can testify effectively in a way that is going to be persuasive, that is going to combat what's coming to them from the defense, combat the stereotypes that are already preset in the jurors' minds. We were talking about Gary Johnson at the beginning offline, and one of the things that I heard recently from Johnson is that jurors almost expect defendants and defense lawyers to lie, and they will give them a pass for all sorts of lying and conduct that they would never give us a pass for. And he talks about how, if you're being sued and someone's trying to take your money, jurors kind of have this idea that it's okay, or it's at least expected, that you're going to say some things that aren't true. You're going to play fast and loose or outright lie. But he also says, and I agree with this, so much, and it's so much of my experience and how I try and practice it in preparing cases for trial and trying them. The opposite is true for us. We have to be squeaky clean, and we can't make any mistakes, especially when it comes to credibility and truthfulness. And the littlest misstatement or mischaracterization that could be thought to be intentional, any untruth, even a small one, can be the death knell. And part and parcel of that is that you really have to work and spend a ton of time preparing your clients. And I hear in a lot of these webinars, lawyers talking about these catastrophic cases, and they always say, I called all these family and friend witnesses, and the plaintiff was on the stand for only 15 minutes. In a case like this, and in most of the cases I do, where medical causation is really in dispute, you don't have that luxury, I don't think. You have to put the plaintiff on and spend a lot of time so that the jury hears the story and hears the issues and deals with the weaknesses from the plaintiff, and it's done in a way that is persuasive, and that they can stand up on cross. And I spent an enormous amount of time with this guy, getting him ready. And we did a number of things. We did focus groups, or we did a focus group. We also, as part of the focus group, but we ended up using it beyond the focus group, and it ended up being a very valuable tool separate from the focus group, is we recorded a simulated direct and cross of him before trial. And the cross was pretty lengthy. It was over an hour. And I actually hired a friend of mine who's a former and retired defense lawyer. And I hired him, I paid him, I gave him the depositions, I gave him the medical records, and I asked him to spend the time to prepare and get ready and really cross-examine my guy, in a robust way. And we recorded the whole thing on Zoom, which is really easy to do now, the technology. And the purpose of that originally was to play a very small snippet of it for the focus group. But what I ended up with after it was done was this recording that was over an hour of cross-examination. And I sat with my client in his apartment, for hours and hours and hours with my laptop, watching and rewatching and pausing and playing and talking and discussing and dissecting this cross-examination. And it was enormously helpful in enabling him to see visually, what was working and what wasn't. And it was a huge help for us in getting him to a place where he could articulate his story successfully. And everything he was saying was real. But as you know, it's not just about what's real. It's about what you can present effectively, and that what can be received in the appropriate light by the jury, and not be affected by all these stereotypes that we deal with. I also worked with a psychodramatist one day with him, because this is a guy who comes from a Middle Eastern country. He's a Muslim guy. Um, in our preparations, I made it clear to him, and he understood that a big part of what he needed to do was open up about the pain and the real emotional impact of how his whole life had really been taken from him because of this injury, but losing his livelihood and his career and his identity. It all goes back to that story about how he worked so hard to get to this place. And so just like lawyers, for so many of us, so much of our identity is bound up in, and our confidence and our ego is bound up in our professional attainments and success. And all of that was taken from him right at the beginning, after he'd worked so hard to get it. And he told me, he said, I come from a culture where men don't talk about their feelings. They don't show weakness, and they don't talk about those kinds of interior pains and struggles. And I don't even talk to my wife about this stuff. This is the woman who has stood by me and been with me through this whole odyssey. And she's like my everything, and I don't even talk to her about it. But at the same time, he was a really smart guy, and he knew that it was necessary that he be able to do this, that he be able to open up. And so, because we needed to do this and we had this challenge, we went and worked with a psychodramatist who helped me help him, or helped him really be capable of bringing that stuff out. And those are some of the things that enabled him, when it came time to be on the stand, to really, really hit the ball out of the park. And again,
Amazing.
everything he was saying was, you know, all the truth, but it came out in a really effective way. And that was a big component in the verdict.
How's he doing now?
He's doing somewhat better, but what happened with him was he had the second surgery, the laminectomy, to make space for the nerve, but that second surgery didn't work, and he remained really symptomatic, really limited, and he really, really didn't want to do a fusion. He tried all of these cutting edge pain management techniques, like lipogems, and he traveled down to Atlanta twice on his own nickel to have these special injections with this neurosurgeon who was doing them down there. Nothing worked. And then he ultimately had a 2-level fusion in, I think, 2020. And he didn't get good relief from that either, and essentially ended up with like a failed back syndrome by the end of it, and was really in bad shape by the time of trial. And I think it's something that's going to be with him for forever. But he certainly got a lot of vindication, and he got a lot of closure from the end of this case, and he's in a position to get himself the best care that is available. And I think he's trying to do the best that he can.
Stephen, in working on this case for so many years and seeing a professional who had their career taken from them, and you talked about the parallels between doctors and lawyers, did it have any impact on you in the sense of gratitude for being able to practice? Did it change your view in terms of the practice of law and the way in particular that you practice it?
I think, you know, yes, and in the aggregate, um, I think when you're representing folks who are going through such suffering and having their lives interrupted or destroyed or impacted, um, it's hard not to let it affect you. And I think the struggle that I have is not to be too pessimistic and too worried always about the worst things happening in life. Um, I think you're right that the best lesson you can draw from it is gratitude. But the thing that I struggle with, overall doing the kind of work that we do, is not causing it to make me, always worried about what can go wrong. And particularly like we're both fathers and families, and you worry so much about your family. I think it can be challenging doing the work that we do, not getting stuck in a mindset of always worrying about um, all the bad stuff that could happen, and enjoying you know just enjoying life and not being too risk averse. It's something that I struggle with.
I catch myself at times waiting for the other shoe to drop.
Correct. That's a big thing for me.
Yeah.
So that's
You did
my honest
amazing
that's
work.
my honest answer. You know.
Thank you. I appreciate the honesty. Uh, I mean, there's so many lessons to be drawn from the work you did on this case. One was the incredible investment of time, and it sounds like it was a pretty damn expensive case that you could have lost. So, just a lot of admiration for the hours and the money that you put into a case that you could have gotten poured out on causation. But the reason you didn't, in addition to the defense kind of playing right into your hand, was just the enormous amount of work you put in. So again, and I hope you pat yourself on the back, and I'm very glad that this doctor had you representing his legal interest. Stephen, for folks who want to get in touch with you for any case in New York, are you barred anywhere else?
Just New York.
For folks who want to get in touch with you about any cases in New York, what's the best way for them to do that?
I think the best way is to go to my website. It's NY Trial Esquire, NY Trial, and then Esquire spelled out ESQUIRE.com. They can find me there.
Excellent.
Thank you.
Thank you for coming back on the podcast. I'm looking forward to our third episode together, when we dig deep on your most recent multi-million dollar verdict, unless you've had another one since then, which
Not
is
yet.
highly possible. Um,
Not yet.
so the role that jury selection and perspectives on the jury throughout the case really played, and some of the lessons you drew from it. So once again, thank you for taking time to join me.
You got it. It's always a pleasure. Thank you so much for having me on.